Good morning, you're Von Zell Hall, and in 241747, Mr. Hall is charged with murder, and what is the announcement?
Murder charges. No warm-up, no filler, straight into the highest stakes possible. A life on the line. But the defense? Still waiting on crucial forensic downloads. In a case this serious, every delay could tip the scales. Time is slipping, and the pressure is crushing.
Your Honor, the last setting requested some digital media. Since then, Mr. Nichols has done an impressive job of providing most everything I need. Unfortunately, I think some of it has to be discuss this with him. I'm trying to get a few more items. I think it would be important to this stage before we announce if I could have it within a 30-day reset.
There was some follow-up testing and some documentation that he was asking that I don't see in my files, so we need to find out if it exists, where it is, and things like that.
So I'll do one more reset. Y'all can work on that. If there's anything that you can get, obviously get that to Mr. Matuska and Mr. Hall. Mr. Matuska will be out there, I'm sure, to visit with you once he gets everything to see what y'all want to do at the next court.
The judge grants one final extension. Not two, not three, just one. The message is crystal clear. Get it together. Court may run on procedure, but behind the curtain, every second is life or death. And this judge, she's done entertaining excuses.
All right, you can go back with the bailiff. Thank you. Good morning. You're Anthony Williams. And Mr. Rojas, will your client waive the formal reading of the indictment? Mr. Williams, in cause number 24.
Next case, felony evading arrest. The defendant ran from police in a vehicle. That's a third-degree felony. No slap on the wrist. This is prison-level serious. A plea deal is on the table, and the court walks him through every consequence, step by step. No confusion, no loopholes.
240401, you're charged with third-degree felony offense of evading arrest or detention with the use of a vehicle from December 7th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a 10-year term in prison, but that would be probated. You'd be on probation for 7 years. There's a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation?
Then comes the brutal fine print. If the defendant isn't a U.S. citizen, a guilty plea doesn't just mean jail time. It could mean deportation, exile, and no way back. Immigration law doesn't pull punches, it cuts deep.
Exclusion from admission to the country or denial of naturalization under federal law. Sorry, state tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Williams is not competent?
There you go.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that I can get a pre-sentence report done. That'll give me more information about you and your case, and then we'll come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today so they can start that report, and she's sitting at that desk right over there. All right, we'll see you back at sentencing. Yes, sir. Mr. Rojas, you have Theron Jackson.
Another defendant steps up with a rap sheet that reads like a crime saga. 3 aggravated robberies, assaults with deadly weapons. His past is stacked against him. But shockingly, the court is still weighing probation. Because sometimes, even at the cliff's edge, the justice system offers a hand instead of a shove. The question is, Will he take it?
Good morning, you're Theron Jackson. And Mr. Jackson was previously in court, entered pleas of true to counts 1 through 5 in each of his motion to revoke unadjudicated probations on probation for aggravated robbery. Actually, 3 cases. An aggravated robbery and then 2 aggravated assaults with deadly weapons. And cause numbers 24 1324. 1323 and 0883. I've received the updated pre-sentence report. This was unagreed, and has everyone had an opportunity to receive that report and review it? Are there any additions or corrections to that report? All right, Mr. Rojas, you may proceed.
Judge, Mr. Jackson recognizes he's on probation for some serious offenses. In my opinion, he needs help. The main problem is mental health issues. He's homelessness, he's got lack of transportation, and he's got limited family here in the area. He tells me that when he was first released from jail, he didn't have a place to live, didn't have any transportation. That's the reason for not being able to get to probation department. He's been on probation for such a short period of time, it seems he's been unable to get the benefit of the resources that probation has to offer. I understand that's because it's not extending probation. But again, I think that all stems from the homelessness and lack of transportation. He is trying to get help for himself. He does have the application to get his government benefits. He's got a contract with someone from MHMR. If he were to be allowed to stay on probation, he tells me that he has a cousin who does live here in Vermont. He is hopeful he can get a job out at the barbecue restaurant.
Hold on.
And of course, that all is going to depend on him actually going to probation. And he does understand that the court is getting there. He will do everything he can to make sure that he does get to probation, because the court will allow him to stay on probation.
He looks broken, tired, lost, pleading for one more chance. His letter spills raw emotion, betrayal, homelessness, even death. But judges hear stories like this every day. The real test: does his pain outweigh his crimes? Or is it just noise against the sound of a cell door closing?
Go ahead.
Hello, my name is Theron Jackson. I'm writing this letter pleading for mercy. I started my probation off on the wrong note. Everything I had on probation was in first place. I ended up losing my cell phone and the place that I was living. The people found out that I was on probation, and they kicked me out the house. And I didn't have, they kicked me out. I got kicked out of the place. I was staying. And the same night, the police had came and arrested me for some unpopular, like some things that I didn't do. And they said I was under intoxication, but I wasn't. You know what I'm saying? Because they was all fighting and stuff like that, and they put me in jail for one night for intoxication, but they didn't have no breathalyzer or nothing saying that I intoxicated. They said I was intoxicated. They was lying. I don't have. They didn't have any record of proof of intoxication. I got to jail and they released me the next day for public intoxication. I reported the next day, the day that I was supposed to report. You know how they let you out of jail. You know what I'm saying? At like 3 o'clock. It was raining so bad. It was flooding. I didn't have nowhere to get there. So I walked. The next day I waited till it stopped raining, and it was unflooded. And I walked to the probation officer, and I told the lady that I didn't have my social security card in my ID, and she said she was going to help me do it. I was very excited, Judge. Trying to get my GED. I was very excited about going to school, and man, the lady kicked me out of the house where I was staying at, and I had to move in the hotel, and I ran out of money, but it just all went downhill for me. If you can find any way for me to get back on probation, I promise I'm going to do the right thing, and I'm a good citizen, and I help anybody I can. I play on minister music, go to church, church right, and yeah, man, I've been trying to stay out of trouble. I've just been running up on hard times. I just been second chance.
Ms. Muffy.
I'm not unsympathetic to this situation. I don't think it's something that is just coming in today, saying that he's had these problems. I think it's been ongoing. I think that's why we initially wanted to give him the opportunity of probation so that he could participate in the next level judgment. Obviously, he's very lucky to have his score as his officer, but I've spoken to her several times about this, and she has gone above and beyond just trying to make contact with him to bring him in to say these are the resources we track that to help you, and they just, fine. I'm not suggesting that necessarily the position is revocation, but that position will be judged, and that's what gives him this opportunity. He does not take advantage of it, he does not do what the court needs him to do, that the court orders him to do, that the recommendation would be significantly higher than education based on.
The judge doesn't shout, doesn't slam the gavel, just delivers a lethal warning. Violate again, and I'll give you life. Simple, final, real. The silence in the courtroom says it all. Everyone feels the weight of those words.
You probably haven't even had enough time to know. I guess my question, Ms. Core, would be if I continue him on probation, would something like cognitive track of ISF be helpful, or that, or either special needs safety? Which one do you think would be more appropriate to help him get a good start before he gets back out? Okay. I mean, Mr. Jackson, everybody wants you to be successful, but you're the only one that can make that happen. You have all the resources. Ms. Core wants to help you. Probation has all kinds of things to help you, but you have to, they're not going to come, she's not going to come find you. So, if I give you this opportunity today, you're going to go get some help in custody. Listen, and when you're out though, and when you're finished with that treatment, it's going to be your responsibility to go where you're supposed to go, to let her know where you're living, and she's not going to go try to find you. You don't show up, then you're going to be back in here, and we will not be having these conversations. Today, I could send you to prison for the rest of your life for violating your probation. Right now, today, for life, for 50 years, for 30 years, for 20 years. An aggravated robbery and 2 aggravated assaults with deadly weapons. You should probably be going to prison. So you need to understand that this is it. There's no second chance. This is your chance. All right? So I'm going to find that you entered your pleas of true to counts 1 through 5 in all 3 cases freely and voluntarily. Find those counts true. Find sufficient evidence in each case to revoke your probations and find you guilty, but I'm not going to do that. I'm going to continue your probations in each of your cases. I'm going to order in each of your cases that you enter and successfully complete the special needs track of safety. That's going to give you all kinds of help to make sure when you get out, you're ready to go and you'll be making better decisions. You won't have any issues, hopefully, with regard to any type of drug or alcohol abuse, and you will also have aftercare, a place to live, and things like that. So you're going to have what you need, and it's going to be up to you. All right, good luck to you, sir. You can go back with the bailiff. Thank you, Mr. Warren. Good morning. Are you Cody Dent?
Yes, ma'am.
And Mr. Dent is on probation in 2 cases, 13-17772 and 22-41052 for the offenses of obstruction of retaliation and theft of property Those both have motion to revoke pending. And then there is a new allegation or new indictment in cause number 250807, a burglary of a building. And Mr.
Enter Cody Dent, already on probation, now facing burglary charges. His lawyer's first move? Push for a mental health evaluation. Not just a tactic, maybe a lifeline. If trauma or illness are fueling the crime, the court could lean toward treatment over punishment. But nothing's guaranteed.
Yes. Your Honor, I've been hired to represent Mr. Dent. I went out and visited with him this past weekend, and I've also spoken with him this morning. And as a result of my evaluation and talking with him, I believe it's merited to have someone appointed to give a professional evaluation. We realize that he is on probation. I realize there is a new charge. This is our first setting. I've not had an opportunity to complete discovery, but I think on getting the information from our discovery, and if we can set for a bond hearing at a later date, maybe next week, if possible, we believe that the results of that evaluation will show that there is possibly some alternatives that are available.
So it's set for bond hearing today on those motions, but you want some time to get up to speed on that other case. You want me to put that off, just hold it?
Yes.
Okay.
Yes.
All right.
At least until next week. I'd like a quick turnaround because right now there is no bond.
Right.
And he needs to get assistance.
Okay. An evaluation won't happen in a week.
I understand.
Okay, so you still think give you a week to get up to speed.
Correct.
Bond hearing next week,
Correct.
and then I'll look at your motion for the evaluation. We'll take care of that.
And I've talked with the prosecutor.
Okay. We'll reset it. How's next week? Are we?
Yes.
We're good. Okay. We'll reset it for 1 week for a bond hearing on those two motions.
Right.
Thank you.
Thank you, Your Honor.
Good morning. Are you Justin Franklin? And in cause number 250514, Mr. Franklin's charged with aggravated robbery. Mr. Lewis, what is the announcement?
Judge, may I put a few things on the record?
Yes, ma'am, of course.
First, may I have the name Kayla Davis?
Will you call the name Kayla Davis, please? Good morning, ma'am. Are you Kayla Davis? Miss Malfino, do you need some time maybe to visit with her, or do you want to go ahead and put something together? Okay. Ms. Davis, would you please raise your right hand? Do you swear or affirm the testimony you'll give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, ma'am. Thank you. Go ahead.
Ms. Davis, would you please state your full name for the record? And Ms. Davis, what is your relationship with the defendant, Justin? Okay, and how long have you all been married?
And then, the most unpredictable twist in any domestic case. The alleged victim changes her story. Suddenly, no robbery, no threats, no violence. Just a misunderstanding. Now the prosecution is stuck. If she's lying to protect someone dangerous, the cycle could repeat. The courtroom is a powder keg, and no one knows if it's about to explode.